Something you asked ChatGPT last week just got admitted as evidence in a criminal trial. That's not hypothetical. It happened in June 2026 in the Palisades wildfire arson case. A defendant's private conversations with an AI assistant were retrieved by prosecutors and used to argue guilt. It wasn't a hack. It wasn't a data breach. This was a completely legal court order. And here's what's wild. There's no law yet that clearly governs how AI logs can be used in court. The prosecutors knew it, the defense knew it, and a judge said yes anyway. This is the story nobody expected, the moment when your private chats with a machine became fair game in the criminal justice system. The Palisades fire devastated Los Angeles in May 2026. Thousands of homes destroyed, and investigators zeroed in on arson. When they got a search warrant for the defendant's phone and email, they included ChatGPT history, and OpenAI handed it over. No fight, no legal challenge. Now prosecutors are building their case partly on what this person asked an AI. That's not just evidence. That's a fundamentally new category of surveillance. We're about to see what happens when the legal system catches up to AI. And here's where things get complicated. The Palisades fire hit Los Angeles hard in May 2026, one of the worst fires in recent California history. Thousands of homes burned. That investigation was massive. Firefighters and law enforcement quickly suspected arson. When they identified a suspect and sought a warrant, prosecutors didn't just ask for text messages or emails. They asked for ChatGPT conversation logs. OpenAI complied with the warrant. That's standard. Companies have to follow lawful court orders. But what made this unusual was that the prosecutors were willing to use an AI conversation log as evidence. Prosecutors weren't treating ChatGPT like a witness or an informant. Instead, they were treating the conversation history itself as a factual record of what the defendant had said and thought at a particular time. Think of it like a diary, except the diary's responding. For years, legal systems have dealt with emails, text messages, search history, financial records, all digital evidence with clear precedent. But ChatGPT conversations are different. An AI sits on the other end. There's no guarantee the conversation was entirely private. The AI doesn't have a lawyer. Nobody knows exactly what data went where. So when prosecutors walked into that California courtroom with screenshots of ChatGPT logs, things this defendant had typed to a machine, they were stepping into untested legal territory. The judge allowed it. That single decision opens a massive door, and nobody quite knows what's about to come through it. Here's what we actually know about how prosecutors accessed the logs. They got a search warrant, a normal court order. They sent it to OpenAI. OpenAI checked the warrant, verified it was legitimate, and provided the data. That's the process for any company holding user data. But the thing that's legally murky is what they do with the data once they have it. Digital evidence from phones and emails is familiar territory. Prosecutors show a text message. It's clearly from the defendant on a specific date. There's a digital signature. There's a chain of custody. There's precedent for how it's presented and cross-examined. ChatGPT logs are messier. When you ask ChatGPT something, you're not creating a document the way you do with email. You're having a conversation with an AI system that's processing your input, generating a response in real time, and logging the exchange. That log is stored on OpenAI's servers. When prosecutors get access, they're getting a transcript, but they're relying entirely on OpenAI's technical integrity and accuracy. Nobody independently verified that transcript. Nobody checked whether the logs could have been altered. Nobody knows if there's a gap in the record. More importantly, and this is the legal question that courts haven't really answered yet, does a conversation with an AI have the same evidentiary weight as a document you intentionally created? That's the unsolved problem, and the Palisades case just answered it. Apparently yes, but maybe not. The legal system is still figuring this out. So what exactly did the ChatGPT logs show in this case? The specifics haven't been fully disclosed. This is an ongoing trial. But prosecutors indicated the logs contained conversations about the fire, the locations involved, and timeline details. That's the legally damaging part. If the defendant asked ChatGPT something like, "How fast does fire spread in dry brush?" or "What time do firefighters respond?" those aren't confessions, but they suggest motive and knowledge. They indicate the defendant researched fire behavior before the fire happened. Now compare that to other digital evidence. If prosecutors found Google searches for the same topics, nobody would question it. Those are clearly intentional queries, but ChatGPT is different in a subtle way. When you ask ChatGPT something, you're not thinking of it as a permanent record. You're thinking of it as a private conversation with a tool. You might ask hypothetical questions, test ideas, or ask things you'd never ask a human, things that seem innocent in context, but look damaging when isolated. ChatGPT doesn't judge. You can ask it anything. That's why people use it. The legal system hasn't fully grappled with this. Should questions you ask a non-judgmental AI have the same evidentiary weight as intentional documents? In the Palisades case, the answer was yes. But the defense might argue that's not fair. This isn't the first time AI data has shown up in court, but previous cases handled it differently. In fraud cases, prosecutors have introduced AI-generated documents or communications, but those were usually emails or messages that the AI created for the defendant, things the defendant then sent out. That's different from asking an AI a question in private. There's also precedent with search engine data. Your Google search history has been used in criminal trials, but Google searches feel different to people. You know Google's logging everything. It feels public-ish. ChatGPT conversations feel private. They feel like talking to a personal assistant who has no connection to the legal system. Yet from a technical standpoint, they're both just data on servers. Both Google and OpenAI hand over data when served a warrant. The comparison that matters most is this. How does a ChatGPT conversation compare to a diary? Diaries have been used in court for centuries as evidence of what someone knew or thought at a particular time. A defendant's personal diary can be damaging if it contains incriminating thoughts. But a diary is physical. It's clearly the defendant's property. It's clearly intentional. A ChatGPT conversation is none of those things. It's hosted on OpenAI's servers. It's half the defendant's words and half the AI's words. It's partly the defendant's thinking and partly the AI's output. So is it really the same as a personal diary? The Palisades case treated it like one. That's the precedent now, and it changes everything. If ChatGPT conversations are fair game in court, the privacy implications are massive. Right now, millions of people use AI assistants to think out loud. They ask ChatGPT for medical advice before talking to a doctor. They ask it for legal advice before hiring a lawyer. They ask it for personal advice before telling friends. They use it to brainstorm, to vent, to explore ideas that might seem bad if taken literally. All of that is now potentially discoverable in a lawsuit. More concerning, criminal defendants can't rely on attorney-client privilege with an AI. If you ask a lawyer a question, that conversation is protected. The government can't subpoena it. But if you ask ChatGPT the same question, there's no protection. OpenAI isn't a lawyer. The conversation isn't privileged. It's just data. That creates a weird incentive. Talk to a human lawyer and you're safe. Talk to an AI and you're vulnerable. There's also the question of accuracy. If an AI misunderstands your question, or if you phrase something carelessly and the AI runs with it, that misunderstanding is now evidence. It's not your original thought. It's a garbled version of what you meant, but courts might treat it as clear evidence anyway. This trial is setting a precedent that no court has fully thought through. Defense lawyers are already challenging it, but the judge allowed it. That's the new reality. The implications ripple everywhere. So what should you actually do with all this? First, understand that anything you type to an AI can theoretically be subpoenaed. It's not secret. It's not protected. If you're facing litigation, a criminal investigation, or even a civil dispute, assume that ChatGPT conversations are discoverable. That doesn't mean you did anything wrong. It means you should be thoughtful about what you type. Second, if you need actual legal or medical advice, talk to a licensed professional, not an AI. Attorney-client privilege is a real thing. Doctor-patient confidentiality is a real thing. Those are protected. AI conversations are not. Third, be aware that your tone matters. If you ask ChatGPT something casually or hypothetically, the courts might not care about the framing. They might just read the words. Fourth, consider what's permanent. Text messages can be deleted. Emails can be deleted. But your ChatGPT logs are stored on OpenAI's servers. You can delete them from your end, but OpenAI might keep them. That's in their privacy policy. Finally, if you're in a situation where you might face legal scrutiny, be more careful. Don't use AI to explore ideas that could be misinterpreted. If you need to think through something sensitive, do it with a qualified human professional. The legal system is still catching up to AI. Until there's clearer case law and legislation, caution is reasonable. ChatGPT conversations are permanent. They are discoverable. They might show up in court. Here's what this moment means. For years, we've treated AI like it's outside the legal system, this separate realm where the rules don't quite apply. But the Palisades case shows that AI is now fully embedded in how courts work. Your conversations with an AI are data. Data can be evidence. Evidence can be used against you. That's not a threat if you're not doing anything illegal. But it does change how you should think about AI. It's not as private as it feels. And it's not protected the way talking to a human professional is. The legal system is going to spend the next few years figuring out the rules here. What counts as evidence? What's fair? What's prejudicial? Those questions don't have clear answers yet. The Palisades case is setting precedent in real time. The defense is appealing. Other judges will weigh in. Eventually, there'll be legislation, new laws that clarify what police can and can't do with AI logs. But until then, we're in legal gray area. The thing to watch is whether courts start treating AI logs differently from other digital data. If they do, there could be real privacy protections. If they don't, everything you ask ChatGPT is basically a permanent record that anyone with a warrant can access. The stakes are huge, and the answer is still being written. Stay alert. Think carefully about what you ask AI, and pay attention to how this trial unfolds. The outcome could reshape how the law and AI interact.